So a wonderful afternoon and a warm welcome to all of you. We are delighted to have your kind presence in the second session of the third International Conference on Mediation. I am Dr. Malvika Upadhyay, postdoctoral fellow at the Delhi School of Public Policy and Governance, Institution of Eminence. And I feel highly privileged to welcome our eminent and illustrious dignitaries in this session today. To begin, may I extend a warm welcome to our chair for this session, Honorable Justice Mr. N. Koteshwar Singh, Judge, Guwahati High Court. We are honored to have your gracious presence among us today, sir. I take this great opportunity to welcome our co-chair, Honorable Mr. Justice Sanjay Dwivedi, Judge, Madhya Pradesh High Court. A delightful welcome to our guest of honor for this session, Honorable Mr. Justice Puneet Gupta, Judge, Jammu, Kashmir and Ladakh High Court, and also the member of Mediation Committee. I also extend a warm welcome to our special guest for this session, Shri Anil Xavier, President, Indian Institute of Arbitration and Mediation, and Dr. Ranjeet Mehta, Senior Industry Advisor. A heartiest welcome to Professor Sarabjit, Kaur, the moderator for this session, and Professor, Faculty of Law, University of Delhi. I also welcome all the dignitaries, professors, researchers, and dear students present in this session. Many thanks for joining us all. Well, this session is indeed going to be very informative and interesting as we will be learning on a very imperative topic, online mediation, challenges and opportunities. I am personally very keen and looking forward to borrow some kind notes of wisdom from our learned speakers. Before we proceed further, may I please inform all of you that during the conference, link for the feedback form will appear in the chat box. Please fill it for the certificates. To open the session, may I please invite now Professor Sarabjit Kaur, Professor, Faculty of Law, to kindly deliver the welcome address.
Thank you, Malvika. A very good afternoon to one and all present here. Honorable Mr. Justice N. Koteshwar Singh, Judge, Guwahati High Court. Honorable Mr. Justice Sanjay Dwivedi, Judge, Madhya Pradesh High Court. Honorable Mr. Justice Puneet Gupta, Judge, Jammu, Kashmir and Ladakh High Court and also member of the Mediation Committee. Shri Anil Xavier, President, Indian Institute of Arbitration and Mediation. Dr. Ranjeet Mehta, Senior Industry Advisor. Distinguished participants, learned colleagues and dear students. I extend a very warm welcome to you all to the second session on online mediation, challenges and opportunities of the third International Conference on Mediation organized by the Faculty of Law, University of Delhi and Delhi School of Public Policy and Governance, Institute of Eminence, University of Delhi in association with Mediation Conciliation Project Committee, Supreme Court of India. With the emergence of internet and increase in online transaction in the 1990s, there arose the need to address dispute arising out of such transactions, and in this lies the origin of online dispute resolution. In 1999, EB started a pilot project to provide online mediation facilities for disputes arising between buyers and sellers on its platform. With the success of ODR at eBay, the world witnessed growth of ODR startups and further adoption of ODR programs by government and businesses for efficient dispute resolution. Moreover, our reliance on information technology created new breakable limits in the wake of COVID-19 in a significantly short span of time, where innovations in ICT tools, expansion of internet, and rising affordability of devices to access these services has provided the necessary fuel not only for commercial, professional, and personal interactions and activities, but also for initiatives taken up for dispute resolution. The potential of ODR is not disputed anymore, and e-mediation as a variant of ODR is informed by the traditional process of mediation, where intention is to use the information technology to expand its applicability and provide speedy redressal to disputes. In this context, in today's session on online mediation challenges and opportunities, we look forward to understand the challenges which still remain to be addressed in order to enable ourselves to fully realize the potential of online mediation. We shall understand the benefits, both short-term and long-term, that are associated with the expansion of mediation in virtual mode. How do we address these challenges and maximize these benefits is the critical question that we shall explore in today's program. With these words, I once again welcome you all to today's session on online mediation, challenges and opportunities. Thank you.
Thank you so much for your generous words, ma'am. Now, may I please request Dr. Ranjeet Mehta, our special guest for the session and senior industry advisor. He's also been a fellow at International Visitors Leadership Program of the US government. Dr. Mehta has represented Indian industry in many government and parliamentary committees and has been instrumental in addressing various policy-related issues in infrastructure, real estate, power, renewable energy, oil, gas, water, and logistics sectors. With immense respect, sir, may I request you to kindly share your views on online mediation, challenges, and opportunities. Over to you.
Thank you. Thank you, Dr. Malika. It's my privilege to be here. Good afternoon to everyone. The chair of the session, Mr. Justice N. Kuteshwar Singh, Judge, High Court of Guwahati, Honorable Mr. Justice Sanjay Dwivedi, Judge, Madhya Pradesh High Court, Honorable Justice Mr. Puneet Gupta, Judge, Jammu and Kashmir, Ladakh High Court, and also member of Mediation Committee, Mr. Anil Xavier, President, Indian Institute of Arbitration and Mediation, and Professor Sarabjit Kaur, Professor in charge of Law Center 1, and my very dear friend, Professor Dr. Ashutosh, who is also Ashutosh Mishra, who is also the in charge director of this program. I thank him for inviting me here. This morning, when I was attending the session, one of the very important references in the mediation was brought out by the professor by the Vice Chancellor of Delhi University, and also by Mr. Justice Kaur from Supreme Court, that the mediation starts right from the Mahabharata days, when Sri Krishna was the first mediator who had organized the mediation between Kauravas and Pandavas. So therefore, if we just go to recent history, like our Gram Panchayats or Nyay Panchayats, they were the platform for mediation. But in between, when the courts started in India, then probably we have seen that this particular service has not been taken by the people for various reasons. However, with the onslaught, with the outbreak of coronavirus 2019, when most of the people went online, and it is normally said that necessity is the mother of all inventions. And we have seen that our courts all over the country, they have adopted the online hearing of all cases, which is commendable. And Indian courts have taken a lead in this. And looking at this, the future of justice cannot be imagined or conceptualized without the vehicle of technology that we have seen during the coronavirus period. Now, for the industry perspective, if you look those 10 parameters which the World Bank comes out every year, where India in 2013 was 142nd out of 190 countries, but in recent years, in 8 years, we are 63rd. However, it is still on 163rd position as far as the contract enforcement is concerned in our country. So therefore, we are lagging behind. Due to this, probably we are lagging behind in coming in, in top 40 or 50 in the world. So therefore, from industry point of view, mediation is extremely critical, because what mediation does is, mediation is also dispute containment. It is also dispute avoidance, and indirectly or directly, it is promotion of general legal health. It promotes the general legal health in the country. So, and possibility of remote resolution really increases that legal health, and it gives access to many in our country. However, there are many benefits of online mediation. People have started it, and as a businessman, when people from the industry, they would not like to get into legal hassles. If the mediation infrastructure in our country is capable, or it is so reliable that people can go there and get the justice, and many the burden on the court will come down. However, today's session, which is on challenges and opportunities on online mediation, I think that online mediation is mostly dependent on digital infrastructure, because today when we see that around 700 million people are having internet access in our country. But if you look at it in rural India, probably that is only around 12-14% access to the internet. However, in cities, it is around 42%. So therefore, it is a big challenge to have a good digital infrastructure. And also digital literacy in the rural areas is only around 32%. So therefore, only 32% people are using internet, that too only through the mobile. When you look at the desktop or laptops, that comes around 8 to 10%, which is a big challenge. So, and people also, overall, when we see is out of, we are 1.3 billion people, only 700 million, around 70 crore people have access. So that comes to around 47% of people are having access to the internet. And when you go into detail, we have seen that around 40% of the litigation in the country is from the government. And we have honorable judges here, and they can see that whether this figure is okay or not. But definitely this is the most cases somewhere related to the government litigation. And second and fourth point, as far as challenges is concerned, and still I think there is a lack of awareness regarding the online dispute resolution, or the ODR. So that needs to be promoted, and people lack trust in ODR services so far. I think despite having given some relief from the mediation, and people are not bound to go with this, they still go to the courts. And one of the finest example we have seen in recent times is Samadhan service, which is for the MSMEs. I think the Samadhan service is very, very useful, where the MSMEs who are not able to get their payments on time, they go to the Samadhan service. I think that here I would like to make a point that Samadhan service for mediation, that can be given some teeth in terms of law, so that people who go there, then once the decision is made on that, they are somehow, again, if they go to the court, then in that case, probably the justice is delayed further. So in that case, MSME still suffers. So this needs to be looked here. And then, the legal culture in our country is still prevents, as I said, due to lack of digital literacy. People do not go to the mediation center, especially online. And then some people just doubt the confidentiality or privacy in the online systems. I think these are some of the things. And last point I would like to make it, enforcement of outcome of ODR process. That is also something which needs to be looked after. I think that these are some of the challenges which are there. However, what we can do is, majority of internet users in our country, when we look at it, below 40 years, above 40 years is only 15%. That means people who are above 40 years of age, only 15% of those people are using the internet services or the online process. So therefore, this is where I think that we need to look at it, that we can have a better digital infrastructure so that people get access to this online services. Now 99% people, when you the exact figure is 99% people out of those 700 million people, they access internet only through mobile. Therefore, people lack the, only around 10% in cities, they access through computers or laptops, and in rural area, only 3%. So when we go for online mediation, in that case, I think that the mobile service will not be sufficient. So these are some of the hindrances. And the time has come that when we need to go along with setting of legal technical hubs across the nation. So these legal technical hubs, they will promote these kind of mediation centers. I think here the judiciary can play a very important role, and a lot of consumer mediation cells need to come in our country so that all the cases which are lingering in the courts, especially in consumer courts for years, and there's no decision on that, probably that can be sorted out through that. And for like to adopt the government, I think that since 40% cases are from government, probably the government can go into the complete online mediation. I think if it starts from the government side, that will make a big difference in above all scenario in the country. I think that with many judges being here, some of the industry point of view that I have given why online mediation is extremely critical to have in our country and how that we can do. I think that I'll be very, honestly looking after to hear from the honorable justice who are present here, 4 or 5 honorable justices, and I look forward to hearing from them. And thank you very much, University of Delhi and this Institute of Public Policy for having me invited in this August conference. Thank you very much.
Thank you so much for your informative words, sir. Indeed, I personally learned a lot. You used wonderful statistics to highlight the relationship between COVID and the importance of digitalization, paucity of laptops, which I think is some of the common problems which people face. Thanks so much for bringing them up to the surface. To take the proceedings of the session further, may I now invite our special guest, Shri Anil Xavier, President, Indian Institute of Arbitration and Mediation, also a member at Independent Standards Commission and Ethics Committee, International Mediation Institute, Netherlands, Chairperson Accreditation Committee, Asian Mediation Association, Hong Kong, Senior Fellow at Hamline University School of Law, USA. Along with these positions, sir has held multiple other prestigious positions at many national and international forums. So may I kindly request sir to please take the virtual podium and enrich us with his talk on online mediation opportunities and challenges. Over to you, sir, please.
Thank you. Thank you, Dr. Malavika. And respected Chair, Justice Kodishwar Singh, the co-speakers, Justice Sanjay Dwivedi, Justice Puneet Gupta, Dr. Sarabjit, Dr. Ranjeet Mehta. So it's a great and of course the dear friends and participants in the conference. When we talk about online dispute resolution, it has become a very important mechanism as it represents significant opportunities for access to dispute resolution, especially by buyers and sellers concluding cross-border commercial transactions. It can be B2B disputes or it can be B2C disputes. See, the rise and importance of online dispute resolution is evidenced by the recent discussions in relation to ODR that has happened at the UNCITRAL, at the ISO, and at the APEC. There were very recent meetings that had happened. In fact, Working Group 2 of UNCITRAL, which deals with online dispute resolution, had recently conducted a colloquium that is from 28 March 2022 to 1st of April 2022. In fact, I had the privilege to participate in the UN Colloquium as a observer member of the Working Group 2 in my capacity as the chairman of the Asia Pacific Center for Arbitration Mediation. In fact, the colloquium had representation from 73 countries and 57 international organizations. Based on the resolution made by the General Assembly of the UNCITRAL adopting the technical notes on online dispute resolutions, we had discussed in the colloquium the scope, options, and issues relating to dispute resolution in digital economy. In fact, the ODR has shifted to a next stage of dispute resolution in digital economy. In short, it is called the DRDE. And DRDE has become the latest trend in dispute resolution, especially in online mode. In fact, online mediation, when we talk about online mediation or online dispute resolution, it should not be confused with virtual mediation done with the help of online conferencing platforms like Zoom. ODR requires a technology-based intermediary. In other words, unlike an offline ADR, an ODR proceedings cannot be conducted on an ad hoc basis involving only the parties to the dispute and the neutral in a virtual platform. Instead, to permit the use of technology to enable dispute resolution process, an ODR process requires a system for generating, for sending, for receiving, for storing, for exchanging, or otherwise processing communications in a manner that ensures digital or data security. Such a system is referred to as an ODR platform. So any mediation that happens over a ODR platform like a Zoom cannot be considered as an online mediation. It's only an ADR mediation or a offline mediation happening in an online platform. So increased digitalization, use of technology, expedited procedures, use of artificial intelligence, and other innovative measures will definitely change how disputes will be resolved in future. In fact, the government of Japan had submitted a report on the developments of dispute resolution in digital economy in the recent colloquium that happened in the UN. Online dispute resolution, as already Dr. Ranjeet has said, has got obvious benefits like speed or efficiency. This would be particularly useful for disputes arising out of cross-border e-commerce transactions, where traditional judicial mechanism for legal recourse may not offer adequate solution. With respect to use of technology in international mediation, it was reported, because there was a study conducted by many international organizations during the COVID period, and it was reported that online mediation resulted in a higher settlement rate than conducted offline. Benefits of mediation was also highlighted with respect to disputes with respect to MSMEs. But there is also a need to understand the dangers and to set right the issues faced in online system. It was pointed out that efforts could be made to address problems that arise mostly due to technical difficulties and environmental distractions. It is desirable that ODR proceedings be subject to the same confidentiality and due process standards that apply to dispute resolution proceedings in an offline context, in particular to the independence, neutrality, and impartiality. In fact, during the colloquium, ultimately we came to a conclusion that it was stressed that preserving procedural fairness was key in online mediation, which would be to ensure equal treatment of the parties, taking into account any imbalance in technological competency, maintaining the neutrality of the mediator so as to build trust, provide a consistent and predictable proceedings, and imposing proper ethical standards. In that context, reference was also made to the standards and guidelines of the International Council for Online Dispute Resolution, that is the ICODR, and also specifications and standards maintained in the Seoul Protocol on video conferencing in international arbitration, because the Seoul Protocol had brought out all the ethical requirements for international arbitration in online mode, and also the UK Jurisdiction Task Force Digital Dispute Resolution Rules, which was made for on-chain digital relationships such as smart contracts. So all these guidelines given by these international instruments had to be made applicable for online mediation to be made more effective. Access to appropriate and adequate technology for ODR has become a vital element to ensure equal access of justice to all. As such, I think there is a need to explore the development of an international legal instrument that could facilitate access to justice through ODR, not only to set out the minimum core standards that will apply to ODR proceedings, but also to prescribe appropriate standards for ODR providers and also to ODR platforms. As far as I can tell you, the Asia Pacific Center for Arbitration Mediation is going to implement a common standard for dispute resolution in digital economy in 10 countries. That is, the process of mediation, the standards of the digital platforms that will be used for mediation, the digital safety that will be followed, the technology and the artificial intelligence that could be made up. All these will be stabilized, and it will be a common system that will be implemented in 10 countries. So, considering the time frame that is given, I think I'll stop here. And thank you for inviting me for the mediation conference. I would like to place my gratitude to the Delhi University and also to the MCPC. Thank you.
Thank you so much for your wonderful words of learning, sir. Indeed, a beautiful juxtaposition was made of online mediation with the International Council. It was indeed very, very learning I'm sure a note of learning for all of us. Now, may I please request our guest of honor for the session, Honorable Justice Mr. Puneet Gupta, Judge, Jammu, Kashmir and Ladakh High Court, and also the member of Mediation Committee, to help us articulate the topic online mediation, opportunities and challenges. So over to you, please. Thank you.
Brother, you have to unmute yourself, Brother Justice Puneet. You have to unmute yourself.
Yes.
Thank you, sir. Good afternoon to all, esteemed brother judges, distinguished speakers, organizers of this conference, other participants joining through virtual mode. Privileged to be part of the third International Conference on Mediation. The topic itself reveals the challenges that the online mediation face or likely to face in the times to come. Mediation, as we know, is one of the forms of alternate dispute resolution where the parties to a dispute choose to settle their disputes by avoiding technicalities of court procedure, and a neutral third party mediates and facilitates communication between them and try to resolve their issues. Online mediation is quite similar, as we know, to the usual form of mediation, the difference being that unlike in physical mediation, in online mediation, the parties to a dispute and mediator do not engage in a face-to-face communication, but instead communicate and converse with the help of various virtual platforms like video conference. The details of the parties and issues are kept strictly confidential, and procedures are conducted through secure platforms. Online mediation, and particularly through video conferencing services, parties can now easily and cheaply communicate with one another in real time. Mediators can use email, text messages, automated systems, and other forms of technology to converse and coordinate during the mediation process. Before the COVID-19 pandemic, mediators and other negotiators used to interact with the parties in person, as that would build trust and rapport during such interactions between the parties. The body language of the participants and their freedom to express during sessions were found beneficial by the mediators in resolving conflict resolution. The lockdowns and social distancing restrictions had taken the world by storm by the end of quarter of 2020, and we are still grappling with that storm. The pandemic has in a way brought to the fore the need for online mediation. Pandemic or no pandemic, the online mediation is here to stay and has to be in place as the world is changing and moving at fast speed, and therefore old concepts have to give way to new methods in tune with the changing times. The shift towards online conflict resolution is going to be accepted and recognized soon by those who are apprehensive of success of alternate dispute resolution process online mode. Conducting mediation online will pose certain challenges. One is establishing the trust of the parties during online mediation. The apprehension of the parties to participate in this mode will be genuine one, as the online mode mediation is going to be new concept for litigants. The mediation through video conferencing or other modes, though to bring parties and mediator together, yet not being huddled physically, will be missed by the parties. The mediation proceedings have purpose and not mere formality. That feeling is required to prevail during such mediation mode, as in the absence of the same, the whole exercise of mediation will be futile one. To overcome this so-called shortcoming in the mediation process, mediators may be required to guide the parties of how the mediation platform works and explain features until participants feel comfortable with them. Pessimism about the process will only derail the whole process, and that has to be avoided at any cost. Conflict resolution lacks the contextual cues we use to read each other. Modes like emails and phone calls cannot indeed convey the visuals of the participants and thus a lack of physical presence. Video conferencing offers more audio and visual cues, but still cannot have the complete luxury of personal interactions. On video, direct interaction and interjection may not be that smooth going, as the participants are unable to speak at that time, the same time, and do not make direct eye contact. Mediator, in order to deal with the said issues, will have to coax, I should say, the litigants to communicate and express their thoughts and feelings as clearly and loudly as possible. Mediator should also be patient and prepare himself for repetition of what is happening during the proceedings, and even pause conversations wherever required and ask parties for clarifications if required during mediation. We cannot be oblivious of the fact that the participants in the online mediation may not be otherwise tech savvy, and that is why they are to be informed of the whole process so that they are mentally prepared to accept the online method of mediation. In short, the participants should have no misgiving of what is taking place in the mediation. The role of mediator is, of course, challenging one in the whole process. When the online mode for dispute resolution is adopted, participants will act and behave differently, and difficulty is to surface in understanding the interest and interpreting their views in the manner they intend to express. The mediator is to understand the viewpoint of litigant and convey it to the other party with clarity so that the dispute is resolved effectively. The hit and trial method cannot resolve the dispute. The mediator has to remain patient, receptive, and perform his function impartially and not fall prey to the fundamental error of taking sides in the process, as a fraction of manifest inclination towards one party on his part can disrupt the whole proceedings. And unlike physical mode, in online mode, party may not give another chance to the mediator to make his point and walk out of the proceedings. The responsibility of the mediator in this mode will be immense. Another immediate challenge is inaccessibility of large chunk of litigants to internet services. Dr. Mehta has already spoken on this and has given number, which is otherwise quite alarming so far as keep in place this mode is concerned. In many parts of the country, there's no access or uninterrupted access to internet services is not available. At the same time, there are people who are not accustomed to or not comfortable with using the technology. Even the mediators may not be trained enough presently to conduct online mediation. The mediators are required to be trained for the technology. One of the most crucial and challenging tasks in online mediation is level of secrecy and confidentiality, which is required to be taken care of, which is otherwise easy to maintain in physical mode. The confidentiality of proceedings can somewhat get diluted and rather exposed in the online mediation if there's a technology lapse. There is no room for pilferage of mediation proceedings during online mode, as the privacy of what transpires during the proceedings is essential. The ever-expanding web world brings with it the threat of hacking and stealing the data, and can derail and degrade the credibility of this process. The online proceedings have to be foolproof. There's no doubt about that. E-mediation is though challenging, it can be just as effective as traditional mediation, as stated by other speakers. Once the online mode is considered to be fair, equitable, and reliable one, the same will be accepted even by those who are apprehensive of its efficacy. The commercial disputes are increasing as the economic activity and markets expand globally. And in that context, the resolution through e-mode will be very useful for the business community as a whole. Traditional litigation can be expensive due to expenditures on various counts, which can be significantly curtailed through e-mode. The travel time and distance get curtailed significantly when the persons in present times have no time to engage them in a long schedule. The e-mode can provide increased convenience to the parties involved in the matter, as they can join the proceedings from anywhere in the contracts, in contrast to traditional mediation, where the party has to physically remain present. Online dispute resolution, of which mediation is an essential part, is a field that holds immense scope, not just in India, but around the world also. It has potential to reduce significantly, if not completely, to eliminate the problem of high backlog cases that the Indian judiciary presently faces. Undoubtedly, the party litigant shall seize the opportunity to avail the online mediation once he is assured of its efficacy and effectiveness in resolving the conflict. The new challenges are to surface, and with the changing times, surely the solutions will be found. Thanks once again to the organizers of the conference for giving me opportunity to speak in the conference. May God keep us safe and secure in the trying times of pandemic. Thank you.
Thank you so much, sir, for your great words of wisdom, and also for underlining and explicating a very comprehensive articulation of online mediation, challenges and opportunities, and for highlighting pragmatic aspects of it. After these insightful ideas, I feel fortunate to request our co-chair for this session, Honorable Justice Mr. Sanjay Dwivedi, Judge, Madhya Pradesh High Court, to kindly share his vital ideas and provide to us more clarity and understanding on online mediation. Over to you, sir.
Thank you. Thank you. A very good afternoon to Justice Koteshwar Singh, Justice Puneet Gupta, and all of the attendees and the esteemed guests. I hope all of you are keeping and coping well with these tough times. It is indeed a pleasure to be a part of this enlightening event, which has presented me an opportunity to discuss an incredible fast-growing subject with the coming generation of lawyers, online mediation. It is a topic which needs no introduction, but certainly calls for some attention. As we all know, the essence of the law is separating the wrong from the right and uploading the right over the wrong. But at the same time, the law is also as much about resolving disputes as it is about right and wrong. And in that very spirit comes the concept of alternative dispute resolution, or ADR, as we all know it. Having a self-explanatory name, alternative dispute resolution mechanism are method of dispute resolution, which are alternatives to trial. Now, interestingly, thanks to the huge upward shift in technology that the world is exercising today, the concept of online resolution or ODR has come up. Definition is necessary to guarantee that all participants in conversation and debates are speaking about the same subject. However, the scope of ODR in any conversation might change depending on the context. What does the term online mean? Is ODR referring to the nature of the dispute, such as a facility for resolving online conflicts, or is it referring to the medium used to resolve the issue? Is it an online form of ADR, or can it incorporate the courts and cyber courts technology? Is it just valid in cases where when the parties are separated by significant distance, or may technical factors such as the ability to preserve and change outcomes offer value to attendance-based mediation? ODR is just alternative dispute resolution taken beyond the boundaries of the four walls of a room. This unconventional concept has found an immense boost in the recent time, where almost everything from doctor consultants to court proceedings have gone online. The idea is not just to increase efficiency while decreasing the effort. It is also to take the concept of dispute resolution outside the room for everybody to relish, which also upholding the spirit of the law, justice for all. In recent times, ODR has proved to be a concept that we did not know we needed until it becomes absolutely necessary. When physical access to the dispute resolution mechanism became tough, the recent pandemic has hit the world like a big reality check, which has called for the best of innovations and making use of the technology to refresh the system and come up with unconventional arrangements to carry out conventional tasks, while obviously being more convenient and cost efficient. ODR essentially heads the dispute resolution process out of the user to customize. Humans are using technology in every conceivable field: agriculture, industry, and service. All are example of this. I don't see why our legal system, and more especially consensual dispute resolution procedure, should not take use of technology benefit to the disputing parties. Many businesses and individuals have been forced to rely on technology as a result of the current pandemic. A large number of people had their first encounter with video conversation, electronic signature, and file sharing over safe and encrypted channels. Among others, one such crucial mechanism of dispute resolution is mediation or online mediation. Mediation is essentially the parties coming together with a neutral third party to resolve their dispute without having to step foot into the court. The role of the mediator in mediation is more like a therapist, where he listens to the party in an unbiased manner, understands the situation, and help the parties to arrive at a consensus on their own. A major challenge that can be overcome by shifting this procedure online is accessibility. Now the mediation process can be available for all parties with an active internal connections without even having to leave their homes. While the prima facie idea behind the same may seem shiny, a complete and successful transition to the digital dispute resolution is still a long walk. While the idea of just submitting an application for mediation on a website may seem too good to be true. However, the infrastructure does not support what the circumstances demand. The availability of a strong and stable internet connection, access to the digital infrastructure, and even knowledge of the operation of digital application are still some challenges that hinder the smooth transition to a virtual room of dispute resolution. According to a study conducted by the Center for Communication and Development Studies, India has over more than 600 million internet users. But the rate of penetration, the internet is still around the 50% mark. So just for the sake of drawing up a comparison, access to online mediation is almost as scarce as physical access to mediation and the courts. That being said, there is still a long road to go to complete switch to online dispute resolution, even when it eventually seems to be an upgrade. If these basic tools are not sorted out, even initiating a proceeding between parties will not be possible. In the past couple of years, we have seen more than enough number of times how a stable and continuous connection is key to a smooth dialogue over video conferencing, and how call drafts and video lags can completely derail the conversation and be exhausting at the same time. Interestingly, another area which warrants attention, which talking about the challenges faced by online mediation, is the availability of trained professionals and molding their training in a suitable manner. Training should not be used to fulfill the 40 hours requirement for the title of a mediation professional. Training must be conducted with the goal of equipping or fine-tuning a trainee's communication skill set, tools, and procedure in order for them to become a consensual conflict resolution practitioner. Following these trainings, independent graded assessment should be conducted. Untrained professional may be unable to bridge the gap between the parties, resulting in poor satisfaction and as a result, decreasing interest and popularity in mediation in India. Needless to say, apart from the communication and expression skill sets, the training also has to include an advanced course on the technology to be used for the mediation process in order to rule out any encumbrances in the process. Delving deeper into the subject on similar lines, development of advanced user-friendly platforms that the facility dispute resolution has to be the priority. The importance of online ODR platforms cannot be overstated, as they must be extremely user-friendly in order to facilitate the move from offline to online dispute resolution. Because ODR methods are secret, the security of the proceedings becomes critical. We need a strong data privacy regulations, since that papers and settlements are being communicated through the digital medium. There must be measures in place for both the parties and the neutral to irrefutably authenticate it themselves. A safe and encrypted case management platform would also go a long way towards ensuring the parties' faith in the online dispute resolution. Since trust and confidentiality are the key pillars of an alternative dispute resolution, it has to be ensured that these pillars are kept intact while transitioning to online dispute resolution. Finally, addressing the elephant in the room, as good as the concept of online dispute resolution looks on paper, it has to be properly regulated. Without introducing proper legislation dedicated to regulating this unconventional approach, like any other innovation, this too can lose its shape pretty fast. While at the same time, with the proper regulation and ample room for growth, ODR has the potential to be a game changer. There is already a dire need of a legislation dedicated to governing the process of mediation. And a provision of online mediation can either be strapped in the same legislation, making in a complete consolidated ADR legislation, or an umbrella legislation may be introduced with the purpose of dealing with all ODR related issues. For instance, subject like e-signature, e-stamping, or maintaining record need to be addressed in a legislation to give ODR a real shot at succeeding. Once the aforementioned issues have been handled, incentive mechanism must be developed to pique disputants' interest in online dispute resolution by granting an express legal legitimacy for both the process and enforcement of settlement agreements. India is dealing with a lack of access to justice problem. And if online mediation is developed efficiently, strategically, with sufficient training, infrastructure, and policy stimulation, it would be able to relieve the pressure on the Indian court system. The future of conflict resolution will be defined by ICT advancement and new concept that will make dispute resolution more efficient and accessible to all members of the society. In this regard, ODR has a significant role to play. ODR can provide tailored dispute resolution solution for businesses through simple, accessible, and user-centric method, allowing entrepreneurs to enforce contract quickly. Furthermore, it has the potential to make conflict resolution more accessible to the general public, reducing the pressure on the existing court system. In India, ODR has the ability to decentralize conflict resolution and allow entrepreneurs from all walks of life to design focused ODR procedure to quickly settle disputes. Such tailored innovations will aid in addressing the particular issues that communities experience in settling their conflicts, as well as meet the needs of our varied society in terms of dispute resolution. India is well positioned to emerge at the epicenter for the improvements in ODR due to the need for an effective dispute resolution system and advancement in information technology. Even though the recent year have seen a major step towards the ODR territory, it is still a concept, the potential of which is relatively undiscovered. Like any other delicate innovation, proper nurturing and regulation can transform it into a model of growth in a developed process, and neglecting the same can take those chances away equally fast. Thank you. Thank you very much.
Indeed, a very enriching talk, sir. Thank you so much. It was an honor to learn about the challenges and opportunities of online mediation for me. After the noteworthy words of these distinguished speakers, adding on to the thread of learning, exploring, and articulating mediation, may I take the pleasure of inviting our respected chair for this session, Honorable Justice Mr. N. Kuteshwar Singh, Judge, Guwahati High Court. Sir has also been a former judge at Manipur High Court and has served as acting Chief Justice of Manipur High Court. May I request you to please grace the virtual podium, sir, with your kind words and insightful ideas on online mediation.
Honorable Mr. Justice Sanjay Dwivedi ji, Honorable Mr. Justice Puneet Gupta ji, Professor Sarabjit Kaur, Dr. Ranjeet Mehta, Shri Anil Xavier, Dr. Ashutosh Mishra, Dr. Malvika Upadhyay, and all the participants in today's online conference. First of all, I would like to thank the Faculty of Law, University of Delhi and Delhi School of Public Policy and Governance, Institution of Eminence, Delhi University, which are organizing this third International Conference on Mediation by online mode in association with the Mediation and Conciliation Project Committee of the Supreme Court of India. It is indeed a privilege to be part of this conference. Though I am not really an expert in mediation and my knowledge is very rudimentary, yet I'd like to share some of my thoughts on this very important topic, online mediation, challenges and opportunities. Most of the relevant aspects have been already touched upon by the learned speakers before me. So what I shall be speaking will not nothing new, but emphasize what I think are very important. Mediation, as we all know, is one of the alternative dispute resolution mechanisms, which is statutorily recognized in our country as encoded in Section 89 of the CPC. 4 forms of alternative dispute resolution mechanisms have been recognized, that is arbitration, conciliation, judicial settlement, including settlement through Lok Adalat, and mediation. Of the aforesaid 4 methods of dispute resolution mechanisms outside the court, perhaps arbitration is the most preferred and practiced one, especially in commercial disputes. This has been facilitated by the changes in the law of arbitration and with the adoption of UNCITRAL by many countries, including India, where the courts have adopted an approach of minimum role for courts in arbitration matters. Resultantly, the infrastructure facilities for arbitration has been strengthened to a great extent with many institutional support based ready level. To that extent, I would also agree with Brother Sanjay, who also mentioned for creating a kind of this legal mechanism, legal statutory provisions, uniform statute to be effective all over the country to make it much more uniform. Apart from arbitration, another area where India has achieved great success in alternative dispute resolution is the use of Lok Adalats. In India, Lok Adalats are held very regularly at the state level and are also at the national level under overall guidance of the National Legal Service Authority, NALSA. While at the state level, Lok Adalats are held very frequently, at a national level, also it has been organized on a yearly basis since 2015. And for the last few years, it has been held at the national level on a quarterly basis in every year. In the last Lok Adalat, National Lok Adalat, which was held on March 12, there were 22,65,495 cases settled, which are pending in the court, and which involve settlement of the amount to the extent of 7,717 crores. It's a remarkable time. Many people do not know how much so much cases have been disposed of through this Lok Adalat, and an enormous kind of pressure which is built up on our system has been reduced. All these, of course, relate to motor accident claims, bank recovery, insurance claims, claims relating to negotiable instruments, maintenance, etc. And we also know that, as mentioned by all the speakers earlier, in spite of severe lockdown during the last about 2 years, national Lok Adalats have been held online. And it has been a tremendous success also. Therefore, if Lok Adalat can be held online, why not popularize this mechanism? I'm sure it will be successful if popularized and encouraged and necessary digital infrastructure are provided. And it can help reduce the serious docket problem of our judiciary. As on yesterday, if you see our CIS website, there were 42,50,884 civil cases. I am not mentioning the criminal cases. There are much more than the civil cases pending before the high courts. And at the taluka level, 1,08,30,280 cases. I am again not mentioning the criminal cases pending, which are more than the civil matters. As in criminal matters, the applicability of this alternative ADR form is restricted. Therefore, if you are able to reduce this huge pendency with the help of this online mediation, I'm sure we'll be contributing a lot immensely to our judicial system. At the very name itself of the topics, it suggests it is the form of mediation which is conducted online. Naturally, a very important component of online mediation is the use of the internet, computers and information technology, and a digital platform, which adds another dimension to the existing challenges and opportunities which one finds in the normal process of mediation conducted physically. The use of internet, computer, digital forum itself offers an opportunity and challenge for the online mediation. What are these opportunities? Have been discussed earlier also. Just like any other benefit accruing with the use of internet and information communication technology, the use of online mediation is cost-saving and convenient and facilitates avoidance of traveling for long distance. One can participate in an online mediation by sitting in the comforts of his own home, unlike in the case of physical mediation, and connect with other participants who are located distantly. Therefore, time and cost saved to the parties is immense, and which is one of the greatest advantages of this online mediation proceeding. Yet, by the nature of the methodology utilized, it also entails certain disadvantages and poses certain challenges. Of course, the challenges relating to online mediation are in addition to the challenge of the normal offline mediation. So what we are going to discuss is about the additional challenges when we face engage in online mediation. First of all, the use of internet, computer, and information technology itself is not widespread in our country and is mostly confined to big cities where digital infrastructure may be available. Even if digital infrastructure is available, there are inherent problems associated with the use of digital technology. These aspects have been highlighted by Dr. Ranjeet Mehta also in his speech. Online activities are more difficult to monitor and supervise, which requires certain expertise in the digital technology, unlike in the case of normal physical activities involving physical proceedings. Though rules have been framed by Indian Institute of Arbitration Mediation for conducting online mediation to secure privacy and confidentiality, which are the most important components of any mediation, whether be it offline or online. Now, with the advancement of technology, cyber security is a big concern. And I do not know how far we are able to make sufficient cyber safeguards, even when we are applying these cyber rules to govern these online proceedings. This apart, I'm not sure whether many of the litigants lawyers, and even judges are aware of the benefits and advantages of online mediation, which is very important to be made aware of, and so that it can be made a preferred mode of dispute resolution with these inherent advantages, as mentioned, of time, saving time and cost. Unfortunately, because the challenges faced during this lockdown, compelling most of the courts in India to go online and conduct the court proceeding on online mode, E-Committee of the Honorable Supreme Court of India has taken many initiatives, including for framing of video conferencing rules sometime in the month of May last year. Accordingly, most of the high courts in India have framed video conferencing rules to facilitate seamless virtual court proceedings. Recently, also, the E-Committee of the Supreme Court of India has framed the model rules for live streaming and recording of court proceedings. Thus, there has been a tremendous improvement in the digital ecosystem of our judicial system. We are also aware that some of the high courts have already framed rules for online mediation. I hope we can take advantage of this improved digital ecosystem, and practice of online mediation can be facilitated and increased by popularizing it amongst litigants, lawyers, and judicial officers. As I mentioned also, the role of judges is very critical in suggesting and encouraging online mediation when situations so arises as contemplated under Section 89 of the CPC. I understand there are many trained mediators present today. However, most of them have not been trained for conducting mediation they have been trained mostly for conducting mediation in a physical mode. Therefore, there is also a need to give training to conduct mediation online. Apart from the skill and knowledge required for offline mediation, the mediators are also required to have proper understanding of the use of digital technology. Even if the training in the use of digital technology is imparted to the mediators, yet the challenge still remains as to how to reach out to the parties online to gain their confidence, which is of a different nature. While the art of gaining confidence and trust of the parties by the mediators in a physical mode has been acquired by the trained mediators, doing it in online is a different proposition, where there are inherent problems in understanding the mood, emotions, demeanors of the parties, which are so essential for an effective mediation. Therefore, perhaps it will be important first to analyze and categorize the kind of disputes which are most ideally suited to be resolved by online mediation, like perhaps commercial disputes where human emotions are less likely to be involved. I'm sure about the efficacy of online mediation when it relates to disputes which involve intense human emotions, like in the case of bitter divorce proceeding or claim for child custody. Perhaps at this stage, at this present stage where we are perhaps online mediation may not be proper. But yes, of course, there can be always exceptions. To conclude, what I would say is that to make online mediation popular, what is important is to ensure that secure online platform or software is available. So is the availability of user-friendly software and digital platform. And of course, availability of good connectivity of internet is necessary. These are keys which those who are involved in this arena should ensure so that online mediation can be made popular. A robust digital platform with good technical support system is sine qua non for an effective online mediation. Unless the stakeholders are convinced of the availability of these critical areas of online mediation, I'm afraid excellence in other areas may not be of much help. But last but not the least, the necessity for popularizing it through awareness program is absolutely necessary. I'm sure today's conference will contribute a long way in making this online mediation a popular means of resolution, alternative dissolution. Thank you very much again, and I wish you all the best in your future endeavors. Thank you very much.
Thank you so much, sir, for educating us on this very imperative topic with your great experience, knowledge, and your kind words of wisdom, sir. Many thanks to all the dignitaries for their enlightening words and for helping us comprehend the topic of online mediation better. I am sure each one of us has surely gained more knowledge about this very relevant topic. I wholeheartedly thank our speakers and participants for making this session a success. May I now request Professor Sarabjit Kaur Professor, Faculty of Law, and also the moderator for this session to kindly present her concluding remarks and vote of thanks. Thank you.
Thank you, Malvika. Online mediation is definitely gaining grounds as an effective way of resolution of disputes. As our speakers have highlighted, that like any other mode of dispute resolution, there are both challenges and opportunities attached to it. The need is to explore by way of empirical research the possible safeguards and risk mitigating mechanism which may aid to enhance efficacy of online mediation, keeping its benefits, that is accessibility to justice, cost efficacy, speedy redressal, and convenience intact. Of all the challenges facing us, the strongest seems to be building of trust. In an online setting where parties have varying standard of digital literacy, they are communicating via technology and are highly skeptical, not just with respect to each other's interests, but also the mode of their interaction, specifically in terms of assuring confidentiality. Unless and until trust is built, parties may refrain from sharing information, and until information is shared, there shall be no scope of settlement. Now, as we are hopeful that COVID-19 is nearing its end, would hybrid mode of mediation be an answer in some specific facts and circumstances? Well, possibilities cannot be denied, and with changing times, the endeavor remains enhancement of online dispute resolution mechanisms, along with curtailment of challenges attached to it. With these words, I wish to express our sincere thanks to our chair for this session, Honorable Mr. Justice N. Koteshwar Singh, for making each one of us aware about the crucial and deep insights relating to online mediation. He has pointed out the huge number of cases pending in different courts for years. Online mediation is a way to reduce the pendency and ensure speedy justice. He says greatest advantages of online mediation are it is cost saving, time saving, and convenient. Of course, challenges are there like digital infrastructure, awareness, security issues, confidentiality. Apart from skill and knowledge, mediators should have knowledge of technology. He needs he should know the importance of safe and secure online mediation. There is need to popularize it through various awareness programs. Thank you, sir, for your words of wisdom. I mention our deep sense of appreciation for our co-chair, Honorable Mr. Justice Sanjay Dwivedi. He emphasized that when humans are using technology in every conceivable field, then why dispute resolution system should not use technology? Of course, challenges are there to completely switch to online mode, but we can initiate the process. He mentioned about the mediation training programs to equip trainers with the requisite. He also talked about data protection system that confidentiality need to be maintained. Thank you, sir, for sharing your thoughts with us. I wish to express our sincere thanks to our guest of honor, Honorable Mr. Justice Puneet Gupta. He distinguished between online and offline mediation. There is no face-to-face communication and no direct eye contact. So the role of mediator is very challenging and immense. Mediator has to understand the viewpoint of one party and then inform it to the other. Mediator should be patient and required to be trained for technology. Thank you, sir, for your inputs on the topic. Sincere thanks to our special guests, Shri Anil, Xavier, and Dr. Ranjeet Mehta for enlightening us on the topic. Dr. Ranjeet Mehta explaining the benefits of online mediation, highlighting the importance of digital infrastructure and digital literacy, especially in rural areas, to make online mediation a success. He mentioned about the lack of awareness and trust in online mediation that need to be addressed. Shri Anil Xavier talked about the problem of technical difficulties and confidentiality in online mediation. He emphasized on need of proper guidelines, ethical standards, and safety measures in tune with the international standards. Thank you, sir, for your words of wisdom. My deep regards and sincere thanks to our Honorable Vice Chancellor, Professor Yogesh Singh, for his encouragement and wonderful support towards organizing this program. I thank Professor Usha Tandon, Dean Faculty of Law, for her immense and continuous support in the organization of the program. I extend my special thanks to all the organizers who have been working tirelessly for the successful conduct of the conference, including today's session. I thank each and everyone present here for participating actively in the session. Your presence has indeed made the session a success. Thank you very much.
Thank you. Thank you very much.
Thank you.
Thank you.
Thank you so much, ma'am, and thank you, everybody. Have a wonderful evening ahead.